Is there such a thing as critical natural law? Critical thinking is evaluative. To engage in critical thinking is to make an assessment of how good or bad something is. Critical thinking is a broader category than critical theory. Critical theories are a particular approach to social institutions which seek not only to describe those institutions, but also to change them. Can I argue in this video that a good natural law theory requires critical thinking, that a good natural law theory can be a critical theory because it identifies what is wrong with the laws in any given society. Natural law is a description of a family of approaches to laws. Despite their diversity, what these approaches share is the common commitment that in some sense or other, the basic principles of morals and legislation are objective, accessible to reason, and based on human nature. Those basic principles form a fundamental core of justice against which any human law can be measured. To be a natural law thinker is to ask the question of any law, is it just? The relationship between natural law and positive law is usually described in spatial terms. Natural law is higher law, law made by the highest of all authorities, which cannot therefore be overruled by any subordinate authority, be they an absolute monarch, a sovereign parliament, or a supreme court. Another way of describing natural law is as fundamental law, law which is more basic than any constitution, incapable of amendment. Human rights theories are a modern form of natural law, asserting there are universal standards of justice which apply across all cultures. Human rights theories hold out the promise of being an objective universal standard of justice against which laws are to be measured. But in so doing, they depend implicitly, if not explicitly, on an account of human nature. Because the natural law is based in reality, it does not depend on what people think. The natural law exists regardless of whether it's recognized or rejected. Natural law thinking and natural law reasoning is a form of critical thinking. It measures contemporary positive laws against a standard which is objective and based in reality, not dependent on fashion, tradition, or consensus. So imagine a society in which everyone believes that female genital mutilation or the exposure of newborn children if there are too many mouths to feed are morally acceptable. The critic wishes to say that the laws which permit, encourage, or require such practices are unjust. They must do so on the basis that the true content of justice does not depend on people's beliefs about justice. It was such a conviction that led Gladys Aylward to campaign against the practice of foot binding in China. She saw that foot binding, a practice of crippling women for the sake of a male fetish for small feet, was contrary to the natural law. A good natural law theory asserts that both historical development and contemporary convention can be wrong about what makes for human flourishing. Nature is an alternative criterion for evaluating the justness of laws. Whether a natural law theory acts to reinforce the power of an existing regime or is iconoclastic depends on what is identified as the principles of the natural law. True justice can be appealed to as a revolutionary and destabilizing concept. Natural law theories come in all sorts of stripes. Everything depends on the standards of the natural law adopted. The idea of natural law as a critical concept goes all the way back to the Greek philosophers Plato and Aristotle. Nature was, for them, a critical concept, a way of measuring law against a different standard from convention or history. Natural right, in the singular, natural right, not natural rights, was a standard identifiable by the wise using their reason. It was to be discerned by identifying the perfect end towards which a being or entity was tending. Costas Gezenas argues that the natural law was used as a weapon by ancient Greek philosophers to challenge the injustice of the political rulers of their day. The philosopher's understanding of nature was dynamic and not static, grounded in an aspirational justice which provided a perpetual critique of existing injustice. At a time when the Roman Republic was under threat and about to be replaced by the Roman Empire, Cicero used natural right as an independent standard to critique the abuses by those who had usurped power in the late Roman Republic. This idea of natural right as an independent standard of critique was supercharged by Augustine's teacher Ambrose. When the Roman Emperor Theodosius retaliated for the killing of an army commander in a riot by ordering a massacre of 7,000 inhabitants of Thessalonica, Ambrose excommunicated him. Ambrose excluded from the church the emperor who'd given Christianity its exclusive position as the religion of the Roman Empire. Ambrose was making a very definite point. Rulers, even the Roman emperor, are answerable to the natural law. And we see the same sort of thing in the Old Testament prophets. Although the Old Testament prophets prophesied in the main towards Israel and Judah, there are many examples in the books of Amos and Isaiah and Jeremiah and elsewhere of oracles to the nations. And in those oracles to the nations, we see the prophets speaking against the different people groups around Israel and Judah, critiquing them for their injustices on the basis that they have violated not the covenant with Israel, but fundamental principles of justice and law that they ought to have been able to discern in nature. In the Middle Ages, Aquinas brought together the ideas of Aristotle, Aquinas, the prophets of Israel, Judah, and the teachings of Jesus Christ. In his Summa Theologiae, he wrote an extended section on law in which he argued that the natural law, which the Greek philosophers had identified, was consistent with the law that God had revealed to Israel and Judah. Aquinas maintained that by using reason and reflecting on nature, human beings can work out that murder, theft, and lying are wrong, that marriage should be between one woman and one man for life, that parents should be respected, and so on, just as they can discover the same things by reading the Ten Commandments. Through the idea of natural law, Aquinas contended there was a standard of justice which all people, whatever their religious beliefs, could in principle identify and agree on. This standard of justice was one which could be used to measure the laws and actions of rulers, whatever those rulers believed. The access of each individual citizen to the natural law meant that each individual citizen was always under a duty to decide for him or herself whether that law should be obeyed or not. And Aquinas was saying that in the context of mixed societies, he understood that the kingdoms of medieval Europe included Muslims and Jews and Christians and pagans. Alistair MacIntyre rightly points out that Aquinas' concept of natural law was subversive of both local prejudice and centralizing power. The rules in individual counties, in different kingdoms, and in the Holy Roman Empire all had to be measured against the standards of justice given in the natural law. The point of Aquinas' natural law theory was precisely to ensure that no human authority was placed beyond appeal or beyond question. So a good natural law theory requires critical thinking. It asks the question of any law, is it just? And a good natural law theory can also be a critical theory. The law is unjust. It asks the question, how ought the law to be changed? Now, this critical dimension of natural law was lost when William Blackstone argued that the common law of England was a near perfect reflection of the natural law. He made the mistake of thinking that the conventional justice of his time was equivalent to true justice. All of us are prone to this. Natural law theories encourage us to think outside of our country and our time frame, to read how others have in different times and places thought about what is the order in nature. C.S. Lewis, in The Abolition of Man, gives some examples of the common themes in different philosophies and theologies about how human beings ought to treat one another. But in the final analysis, natural law is not about declaring what is normal or universal to be normative. There is a moral order in nature. The simplest explanation for the existence of such an order is that there is a legislator who embedded that order in creation. The Old Testament prophets, such as Amos and Ezekiel, and critical natural law thinkers, such as Augustine and Aquinas, tested the laws and the lawmakers of their own times against the justice revealed in the actions of the God and Father of our Lord Jesus Christ. Any criticism of law comes from a particular standpoint. Natural law theory tests the assumptions of any society against reality, carries within it the possibility of opening our eyes, the absurdities and injustice in the common sense or unquestioned assumptions of our day. by drawing us back to reality. Natural law theory requires us to think critically and can operate effectively as a critical theory.